Is Prof clearly wrong or wrong clearly? Vehemently.
He's clearly wrong.
Yes.
I think this is wishful thinking. Wishful thinking. If he wants to expand the remedies available in a presidential election petition in the Constitution, and a statute, I mean, he's talking about the Elections Act. And I think this is one of the issues that are likely to feature in this decision. A statute cannot give you powers that the Constitution does not. The Constitution only talks of invalidating. Granted, I think if we now go back as Kenyans, we may want to expand the powers of the Supreme Court in this context. But we have given the Supreme Court a straitjacket, which is why I think it finds itself in a dilemma. If you look at the decision in 2017, in some respects I sympathize with the court because it was in a dilemma. Here is a situation where we'd wish, because we are saying there are votes that express the will of the people. And I disagree with my good friend Ben. In 2017, if you read the decisions carefully, the majority were faulting the transmission and verification process. They were not faulting anything that happened prior. In fact, that was not canvassed. It was not an issue that was canvassed by the petitioners in that case. And that is why I think the minority had some basis for saying, look, we have votes. They declare the will of the people. Why are we getting rid of that as well? However, the dilemma is that the court does not have time. The court has 14 days. It's absurd, 14 days to do the impossible, including saying, let us recount. Remember, even the scrutiny that it does is a very limited scrutiny. And the scrutiny is really just with a view to getting a picture of the nature of the violations, whether or not they were substantial. That is all the court that is doing. But if the court had time to recount, number one. Number two, if we had empowered the court, if we've given that power to the court, not in the Elections Act, but in the Constitution, it would be different. But as far as I see it, that is so far wishful thinking. The Constitution has given the Supreme Court very, very limited powers in Article 140 sub-Article 3. And it only relates to, and it says if the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. I would respectfully submit that that is all the court can do.
I think that's one point on that. Con Law 101. I teach Con Law. The first day of Con Law school class, we say this. The Constitution, three things. Number one, the Constitution is the main law, is the basic law, is a fundamental law, is the first point of reference in any constitutional debate or discourse. Number one. Number two, class in Con Law 101, the first day of class, we agree on this. And most of my Con Law former and current students know this. They can tell you very clearly. Number two, they say that the other laws must therefore be consistent with the Constitution, and therefore they can elaborate on what the Constitution says, because the Constitution deals with broad issues of principal policy. The Constitution is not a day-to-day regulatory law. It's unfortunate. There's a sense in which it's unfortunate that our Constitution is so elaborate, including that the president must be sworn in during the day. That ought to have been regulation, because we don't trust, you know. That number. Lastly, the Constitution is emphatic in Article 2.4, that it is only laws, acts, and omissions, which what we call conduct, and one can add decisions, which are inconsistent with the Constitution, that will be invalidated. There is no showing so far in this debate or in this country that what I have cited as Section 80 subsection 4 of the Elections Act, there is no showing that Rule 22 of the Supreme Court Presidential Election Act is or has been declared unconstitutional. There is no showing that while we have applied them in our presidential election petitions, including issues of costs, there is no showing that they have been declared unconstitutional. And therefore, we have used text, structure, and history, and ended with what our friend Mao Zedong told us. Very important. No research, no right to speak. So when we talk, we must cite text, structure, history.
We continue to disagree.
Yes, vehemently.
A very